So on to the first case. But before we get on to the first case, I should say I need to define what I mean by commercial litigation. Now, of course, this is a term in common use, and everyone knows what it means, but do they? What is commercial litigation? Well, I've set out some options as to what it might mean. One could mean it's only disputes which are brought in the commercial or the circuit commercial courts, which count as commercial litigation. For me, that's too narrow. And indeed, only one of the cases I've selected today is from those courts. So another possibility is commercial litigation is where a dispute arises between parties in a business relationship. But that's not satisfactory either, because a party in business may be in dispute with another business about payment of an invoice, and you wouldn't really call that commercial litigation. That would be a debt collection or debt recovery matter, even though I suppose wider issues might be brought in later in the dispute. So my third opportunity to define commercial litigation is where we look at the subject matter of the claim being a business contract which is in dispute as to what it means and what it requires, or business assets are involved in which the parties are arguing over. So the subject matter of the claim may be a useful guide to what commercial litigation is. But what my overarching points are from this review of the top 10 commercial litigation cases of 2022 as I've selected them, many of these contracts are about contracts, no surprise there, because most commercial litigation is about contract or the existence of a contract or non-existence of a contract, or the meaning of a contract, or the application of clauses in a contract, etc. In some situations, the contracts were given a literal and a close reading. I would illustrate that by case one, that's the ship scrappage case. Delivery of title, not delivery of vessel, triggers the force majeure clause. But in other cases, when wider view is taken, of course, the court isn't deciding should we be literal, should we be wide-ranging. It's simply deciding what the court, in the court's view, the clause means. So my illustration of the wider view, if you like, is the cases relating to liquidated damages, the settlement agreement, and the one we just looked at on the exclusion of losses. Virtually all these cases involve an identifiable area of law, or several areas of law in some cases, with many authorities. And the judgments set out the history of the area in some detail, so they're worth looking at to learn about that. And in some of the situations, and the last one I would say perhaps is of that type, where the outcomes are not always easy to predict. And therefore, that makes settling the case hard because you don't know which way a court will go. And in that case, the Soteria Insurance and IBM case, the first court went a different way to the Court of Appeal. But it only goes to show that's why commercial litigation is fascinating, and that's why I've selected these cases from my review of 2022.